I will go ahead and call the next case. It's People versus Donald Davis. It is a 15-minute mini oral argument on the application. That means each side has 15 minutes, and Mr. Helton, you may attempt to reserve some of that for rebuttal. But as you know, we ask you to try and keep track of that. And if you're ready, you may proceed.
Thank you very much. Stephen Helton of the State Appellate Defender Office on behalf of Donald Davis. I will try to reserve some time for rebuttal, but I'm just going to go ahead. Mr. Davis's trial was closed to the public because the judge had the deputies escort the public out of the courtroom and ordered those people to leave and not come back. And before they left, the judge unambiguously said that the mother of the man Mr. Davis was charged with murdering was the only person allowed to attend the remaining 3.5 days of the trial. The judge didn't need to lock the doors to close the trial to the public because the public was literally removed from the courtroom and the judge's directions were clear. Only one person could attend the remainder of the trial. We know that the people forced to leave understood this because, as the judge ordered, they didn't come back. We also know that Mr. Davis understood this because he communicated it to his stepfather. What we don't know is how many other people who wished to attend learned about the judge's order second and third hand. The closure violated Mr. Davis's right to a public trial because the judge's interest in holding Ms. Fry in contempt or saving time didn't override the interest in a public trial. Mr. Davis is entitled to relief under Carines because the error was plain, and as Judge Schwartzel wrote in dissent, the closure and the majority of the most important parts of Mr. Davis's trial through a conspicuous and non-neutral order seriously undermined the fairness and integrity of the trial. I'll answer any questions the court might have, or I'd be happy to continue.
Thank you, Mr. Helton. Let me see what questions folks have, and I'll start with Justice Bernstein.
Hi, good morning, counsel. I am just kind of curious in a more practical manner to this. If, let's say, a news crew had shown up the next day, what would have happened?
I don't think there's any way of knowing that. We know that Judge Nethercutt said that he didn't instruct the doors to be locked. He didn't order the doors to be locked. He didn't order them to put signs outside of the courtroom. But we don't know how the deputies took the order, if they took it literally or if he specifically told them not to enforce the order. So we don't know.
So how am I supposed to impute that? Because it's kind of ambiguous, right? So, I mean, was there any circumstance or situation where a member of the general public was told that they couldn't enter or not permitted to enter?
I would say there was, and it was not ambiguous. The judge told the people in the courtroom, I think it was 2 to 10 people, Mr. White testified, don't come back, leave and don't come back. The only person allowed to watch the remainder of the trial is Ms. Givens. And we also know that Mr. Davis instructed his stepfather to leave the courtroom when he came in while the trial was not in session. So,
but I guess where this gets a little confusing, and I totally hear and understand and appreciate what you're arguing. I'm just trying to sort through this. What I'm trying to garner is, how do I infer this? These were people that were kind of connected. I'm talking about a member of the general public, a member of a newspaper, a member of a film crew, whoever might just happen to walk into the courtroom who wasn't present at the time of the people being dismissed. How do I infer what would or would not have happened to them? Should I infer that they would have been told to leave? Like, what's the inference I'm supposed to have? What's the burden I should use?
I think this is sure. I think you just have to take the judge's order as it was issued, and accept that as every other public trial case has done in the past. We don't have information about the doors being locked in any of the United States Supreme Court cases, any of the Michigan Supreme Court cases on public trials. The judge, ordered that the trial was closed to the public. He says he didn't intend to. I don't think that's relevant because his intent wasn't conveyed to the public, and so Mr. Davis was inside the trial. So was his attorney. There's no one who was sitting outside of the door who testified. We weren't aware that this would be part of our burden of establishing a public trial violation when we, were remanded to the trial court.
Counsel, thank you very much for answering my questions. I appreciate it.
Thank you.
Justice Clement.
Good morning. I'm just curious on your thoughts on whether this court should adopt a presumption that an unpreserved structural error satisfies the fourth prong of the plain error standard.
Yeah, yes, we think that is a very appropriate remedy. Under the framework that Vaughn set up, we do think this qualifies in that Ms. Given's exclusive presence in the courtroom did not confer any of the protections the public trial right generally would offer. But we cited 19 other Michigan Court of Appeals plain trial violation errors where the Court of Appeals found that defendant wasn't entitled to relief under the fourth prong of Karina's. I know there are several that precede the Vaughn opinion, and there's also other structural errors that have been deemed to not warrant relief under Karina's, such as People versus Duncan, where the jury wasn't instructed on any element of an offense and still convicted. So I think that the Court of Appeals has really struggles with these structural errors that don't necessarily have a specific outcome determinative effect where you can say, oh yes, if this witness hadn't testified. So I think, because of its misapplication of this or difficulty handling this, the reverse presumption, the presumption that a structural error does render the trial unfair, because that is what structural errors are by definition, makes sense. And in cases like Vaughn, where the error truly didn't render the trial unfair, the prosecutor could point to the facts that show that, and presumably deny the defendant relief. So I think that makes sense.
Thank you.
Justice Cavanagh.
I'm wondering if you could speak a little bit about this question of waiver and whether or not trial counsel's sort of tactical decision not to object was a waiver or forfeiture, or what you can say about that.
Yeah, I think I've never I've truly never heard of this this application of waiver in any context. I actually think that the Court of Appeals lacked the authority to create this sort of waiver, because as Vaughn instructed, silence does not waive a public trial violation. It forfeits one, and beyond that, even if this court were inclined to create this sort of strategic silence waiver approach, the United States Supreme Court said in Davis versus Welch, which is the 1923 case, that local practices cannot work to waive a defendant's constitutional rights, and so this concept of waiver, it doesn't make sense. It's counter. It's, I don't know. It goes the opposite way of issue preservation, in that it will require remand for all forfeited errors, so that the prosecutor can try to establish that the error was waived and not forfeited. And it places defense attorneys and their former clients in very difficult situations, where the defense attorney essentially has to admit that he messed up or waive a constitutional right on behalf of his former client. And that said, I don't think there is a case law in Michigan that says a defense attorney can waive his client's constitutional right to a public trial without consultation. So I don't see how, after he's no longer his client's attorney, he could waive the right.
Okay, thank you.
Justice Welch.
Yes, thank you. Mr. Helton, one of the things I'm struggling with is that it seems that Weaver and other Supreme Court precedent prevents us from adopting an automatic reversal rule for public trial violations. And I'm wondering how we're supposed to square that with the case before us today.
Well, I don't think that Weaver does prevent the court from creating an automatic reversal rule because the state constitution does have a public trial right, distinct from the Sixth Amendment. But that said, if any public trial violation is going to impact the actual outcome of a trial, this case, under these circumstances, in the non-neutral manner of the closure, in the conspicuous manner of the closure that kind of conveyed to the jury that these people were dangerous, that this is a scary offense. With the mother being exclusively present in the courtroom for the majority of the trial, this is the type of closure that would affect the trial's outcome. So I don't think we are urging the court to adopt a automatic reversal requirement. We're saying that the Carini's framework hasn't worked since Vaughn, and maybe should be tweaked, or additional guidance should be provided.
Thank you.
Justice Zahra.
The Court of Appeals decision seems to draw a distinction between the type of people who are being excluded from the courtroom. Is there any support for that, or what's your position on that?
Well, I mean that this court's rejected that the Court of Appeals suggestion that, well, because they weren't defendants' family members who were kicked out of the courtroom, that has some sort of impact on defendants' right to a public trial. And the reason is because we don't know. The courtroom wasn't surveyed, and also because it's the right to a public trial means that the public's watching. They can, if the public was present, the prosecutor might have felt uncomfortable saying that people who are innocent don't ask for plea bargains because he might think someone in the courtroom knows better. If the public's watching, maybe Mr. Holliday feels uncomfortable talking about what, saying someone did something that he knows they didn't do. And so, just the eyes in the courtroom, no one, because the public trial right was denied, no one knows how Ms. Givens was acting for the majority of the trial, in the gallery by herself, because Mr. White's eyes weren't on her as he testified. The one time he turned around and he saw that she was weeping as the jury walked past. So these are protections that the public could have afforded that Mr. Davis was denied because of the closure. It doesn't matter that the people present who were excluded were apparently not his family members.
Thank you.
Justice Viviano.
I have no questions. Thank you.
Mr. Helton, you want to reserve your 2 minutes?
Yes, please. Thank you.
You bet. Ms. Clark, you may begin.
Thank you. Good morning, Your Honors. Chief Justice McCormack, Associate Justices of the Michigan Supreme Court. May it please the Court, Alena Clark, plaintiff appellee in this matter. Your Honors, before you today is a case where the defendant, Mr. Donald Davis, received a fair trial, and the trial was a reliable vehicle for deciding Mr. Davis's guilt. What you are really determining here is whether this court will Monday morning quarterback an experienced and respected local defense attorney's decision to not make an issue of a court's ruling that he believed benefited his client. Stated differently, to grant application in this case will mean you find merit in putting an additional and nonsensical burden on both the prosecution and the defense to raise objection to a ruling they don't see as an issue, even where the defense attorney, who is in the best situation to know what is best for their client, where he or she thinks the ruling is not harmful. There are 3 reasons why this court must deny defendants Mr. Davis's application. First, the Court of Appeals did not commit plain error where it found that Mr. Davis was not entitled to a new trial. Second, Mr. Davis's constitutional rights were not violated. And even if you find the Sixth Amendment right to trial, public trial was impacted by the actions of the trial court, the issue is not preserved for appeal, and there is no evidence to support the argument that his trial counsel offered ineffective assistance at trial. And finally, to find that where a competent defense counsel does not raise objection to an issue at trial is still reviewable on appeal will not only create perpetual appellate parachute, but it will also create a chilling effect on trial counsel to not raise objections or to have confidence in their trial strategy. Now, before I move into these 3 points, I just want to address some of the things that were said and raised by Your Honors in Mr. Helton's statement, if I may. First, there is no evidence whatsoever that the deputies removed people from the courtroom. That was not in the record. I'm not sure where that's coming from. They were not escorted out. They were asked to leave. And Justice Bernstein, you asked a question about how do we know if a news crew showed up, if they were able to be allowed in the courtroom. And the answer was provided that we wouldn't know. I disagree. We 100% would know. We have testimony on the remand that shows that people were able to enter the courtroom unencumbered, specifically the defendant's stepfather. Now, I will say this, being a trial attorney myself, I can tell you that if the doors were not locked, people were most certainly coming in and out of the courtroom. People get confused all the time about what courtroom they're supposed to be in. They come and sit down because they thought their case was going to be called, but find out later it was adjourned. It's not abnormal. If the doors are not locked, they are open, and that it is open to the public. Now, also, Justice Cavanagh, you asked about waiver versus forfeiture, and it was stated that this type of waiver doesn't make sense. I disagree with that statement also. There is much case law about not only voluntary, but affirmative steps. This was a voluntary decision. It wasn't just an accidental, I didn't hear the judge, I wasn't thinking about it. This was something that we know on remand, that we have a record to support, was a conscientious decision. This was a strategic decision, and it was made for the benefit of his client. That's what removes us from forfeiture and into the waiver realm.
Ms. Clark, let me interrupt you. I appreciate the answers to the questions, but let me make sure that my colleagues have those same questions, or if they have different ones. I don't want to use up all your time before you hear those questions, if that's okay. So let me start.
Oh, absolutely.
Thank you. Let
Sorry.
me start with Justice Bernstein.
Hey, counsel, good morning, and thank you for addressing my question. Just as a follow-up to it, can a judge ever, and I know there are specific circumstances where this would occur, but can a judge ever ask certain people to leave and not others and allow for that trial to still be open? And I'm not talking about like if it's specific to the nature of that circumstance or if a person is being disruptive. Can a judge say, you know what, these people have to leave, and the minute that is there ever a point where if a judge requests people to leave the courtroom that the trial then becomes closed? Or can a judge be selective as it pertains to kind of who can leave and who can stay, and the trial can be open?
I think that one thing that initially comes to mind is that obviously victims have a constitutional right, and the family members of the victim, to stay. So if the judge were to clear the courtroom, like in a circumstance like this, there's a constitutional right for others to stay. So that would be one circumstance. I think that there's also circumstances where there may be, for reasons of social distancing, for example, that only people for that particular trial could be present, as opposed to people who were waiting for their sentencings to be heard at 2:00. The judge may say, you guys need to go sit in the hallway. We need to maintain social distance practices for those types of reasons. But the one that I think comes most to mind is the one that you didn't want me to mention, which is when people are disruptive. I mean, we have seen even in the trials that we've had during COVID, if people don't have face masks, they're asked to leave. And those are health precautions. So there are certainly circumstances where people will be cleared from the courtroom that I don't think would ever amount to a closure, which is, precluded by the Sixth Amendment.
So hypothetically, because I mean, you kind of went right where I was really going, which was the COVID. Hypothetically, under social distancing guidelines, can a judge basically just simply say I know that this didn't happen here, but can a judge say, oh, well, this is just going to be live streamed, so we're going to make it so that no one can come in? What would your position be on that?
Well, I think that if it's live streamed, that it is open to the public.
Okay,
So
that's what's kind of happening in a number of situations. So I guess my question is as I kind of look at this case and I look at COVID and I look at these kinds of situations, that would be the state's, basically would say if it's live stream, people don't have the right to be in the court in person.
I don't know that they're saying that they don't have the right. I think they're making a decision that it's safer that they stay home. I mean, for example, right now, your courtroom doors are locked. This isn't a closed proceeding. This is still streamed. So it's not
Right.
saying that I don't have a right to have a public hearing or the people of the state of Michigan don't have a right to have a public hearing. You're saying we have to make some health decisions.
Right. No, and you've been excellent with this. Thank you for answering my questions. I know they're a little bit complicated, but I'm just applying this case and thinking about the ramifications of the decision that we're going to make that I think are going to be far-reaching beyond the decision in this case. So thank you for bearing with me and answering my questions.
Justice Clement.
Good morning. Same question I had for Mr. Helton. What are your thoughts on whether this court should adopt a presumption that an unpreserved structural error satisfies the fourth prong of the plain error standard?
I don't think you should do that at all. I think that the reason why we have plain error analysis is because it wasn't preserved. That's the only way we get there. Had this been a contemporaneous objection and Mr. White said, Judge, can we talk about this? Then there's an opportunity for the court to clarify right then. That's what we want to encourage people to do, because certainly it's easy for us in our appellate tower to look down and say, well, you should have done this, but this is why we have plain error. It's hard for a reason. To do something automatic would have the opposite effect than I think that what we all want to achieve. We want the trial courts to do what they were created to do, to function, to provide a fair trial. That cannot occur if we know that, hey, I can make an alternative strategic decision to say, I'm going to roll the dice with this jury and hope to convince one person, and I'm pretending I'm a defense attorney, whereas the prosecution has to convince all 12, right? So a defense attorney only has to convince one juror that their client is not guilty. And then they can say, well, even if I don't win that, then I know I can bring this up on appeal because it doesn't matter if I object and preserve it or not. So I'm comfortable with either one of these. And that's the opposite of what we're trying to do. I mean, we have preservation for a reason. Otherwise, also consider how many appeals the courts would be flooded with. It exists for a reason. There is already a mechanism in place when you don't. I mean, even if we assume that this was a forfeited error as opposed to a waived error, which we maintain, obviously, it was waived. But if we go the forfeiture route, the 4-part test, it works. It's there for a reason. It has worked. I disagree that it hasn't worked since Vaughn. I think that it's very sensical. It provides a lot of options. And I even offer to expand it in mine, which I realize is kind of a reach, but I don't think that there's anything that the court that would merit modifying prior working precedent.
Thank you.
Justice Cavanagh.
Okay, so I appreciate your answer that you just gave to Justice Clement, but if play along with me here, let's say that we were to adopt it, this presumption. Can you tell me what facts would you point to that would rebut this presumption that the error, seriously affected the fairness or integrity of the proceedings?
Actually, if you look at Vaughn, let me find this language. So in Vaughn, they give us the 4 things that either we have a defendant who's presumed innocent or an actually innocent defendant, which there's no assertion of that here, or we have to look at the fair trial, right? So you have to look at what are the goals that the Sixth Amendment are trying to achieve: ensuring a fair trial, reminding the prosecution and the court of their responsibility to the accused and the importance of their functions, and encouraging witnesses to come forward, and fourth, to discourage perjury. So in this case, there is no facts whatsoever that implicate any of those things. The witnesses didn't know about it. They were sequestered. There's no evidence that the prosecutor acted crazy. The judge got a little extra with what he said, certainly. I'm not going to deny that. But it wasn't to the extent where he had the doors locked or anything like that. Nobody knew what was going on. So there's nothing to show that witnesses didn't come forward, that they, were in any way offered incorrect testimony. I mean, obviously there was the argument of credibility as it related to the co-defendant who, said he observed the crime. But those 4 goals are still achieved, particularly with these facts. And I think that this is really relevant because Mr. Helton said that if not this case, then which, or, these are the facts that are right. And I totally disagree. If this were a case where the judge was doing a bench trial, for example, or we had like a star chamber where we're, somewhere secluded where people couldn't come in and the press couldn't come in, then that would be a situation. But I think that there is ample facts here that were pointed out by the Court of Appeals and that I've said here and in my brief that show that it's not the circumstance where a new trial would be granted. Does one exist? Sure, absolutely. There is a circumstance that may require an automatic reversal. This one isn't it.
Okay, thank you.
Justice Welch.
So, Ms. Clark, that was a perfect segue because my question was going to be, when would it be justified? We know under Vaughn, or since Vaughn, we have yet to find a case justifying a new trial. So is it your contention that basically the doors have to be completely locked, nobody can be let in, and that's what meets the threshold?
I think that's part of it. I think that you have to look at these things not in a vacuum. I think that you have to have certainly locking of the doors, absolutely, posting, not available in other places. The thing is with the Sixth Amendment, when they created this, we didn't have technology like we do now. This hearing was not only audio recorded, it was video recorded. We have a transcript evident by the fact that we're sitting here talking about what occurred back then. This is not the type of situation that the Sixth Amendment was created to prevent, where, like I said, star chamber, which they talk about in Vaughn, where secret hearings in a clandestine place, nobody knows about it. There's no notice. Court dockets in this case, and most cases, are public. So is there a circumstance, to answer your question, Justice Welch? Absolutely. There certainly would be. If this were a locked, sealed, hidden, non-public in any way, shape, or form, non-recorded situation, then we need to be concerned.
Thank you.
Justice Zahra.
No questions this time. Thank you.
Justice Viviano.
No questions. Thank you.
You may continue, Ms. Clark.
Okay. Thank you. I want to reiterate that there are certainly circumstances when a new trial would be merited, and we are not contesting that. They're listed in Vaughn, they're listed in Duncan, where there are circumstances that we need to be concerned about. Public trial could merit a new trial, but it is necessary to look at them on a factual basis. And that is what you need to do in this case. Not only do we have an instance where there are not facts to support that this was a closure, it was a clearing, but we also have facts to support that this was a waiver and not a forfeiture. If you open the door to allow unpreserved errors to be reviewed, you're opening a huge can of worms that just is not necessary and does not achieve justice. Your job is to balance not only a right to a fair trial, but the finality of a judgment, which has been articulated many times by the United States Supreme Court. On the other side of this case is the victim and the family. She was told to remain neutral. She did her best, but contemplate. There is no whatsoever contest or disagreement that she lost a son. And to open this back up would be putting her through that as well. Thank you very much.
Thank you, Ms. Clark. Mr. Helton, you have 2 minutes-ish.
Just a few quick points. We think this case shows that unless the court modifies Carinas in the matter Justice Viviano suggested in his dissent in Kane, defendants will never be able to establish entitlement to relief under Carinas for a public trial violation. In Vaughn, the trial was closed during voir dire. Disinterested potential jurors were there to see what happened. Here, the vast majority of Mr. Davis's trial was closed to everyone except for the mother of the man he was accused of murdering. Regarding waiver, the Carter, this court's opinion dealing with whether or not defendants have to be bound by their attorney's decision not to have transcripts read back to the jury. The court held that it was appropriate to bind a defendant to his attorney's choice because that's the attorney's function, and because trials would grind to a halt unless that were the rule. Trial closures are supposed to be extremely rare, so that isn't an issue here. And additionally, Mr. Mr. White obviously did not have all of the facts available to him. Mr. Davis asked him to talk to his mother. He didn't do that. He didn't know that Mr. Davis's stepfather was coming. This is a personal right, and it's not something that a trial attorney can strategically waive, because the effect is unknowable, and the attorney has no way of gauging whether or not the defendant wants to accept his advice or would prefer to have someone like his stepfather there with him, as he has to be going through one of the scarier
Counsel,
things.
I have a question, and I just think that this is something I'm just really focusing in on, just because it's something I'm concerned about is that I wanted to present you a hypothetical in that it didn't occur in this case, but just hypothetically, if a person were to go to the courtroom and the door said, "This door is locked, you may not enter this courtroom under any circumstances," but the courtroom was, you could do it on, you could watch it live streamed. What was your position? What's your position on that? So you go there, the door is locked, you cannot go in, and you're told that you cannot go in, but you can watch it on a live feed, and it says, due to COVID, you may not enter this room or this courtroom, and if you wish to watch it, you can do it on a live feed. Would that be how would you approach that? Is that open or closed?
I think that's closed. The name escapes me right now, but this court's opinion last year on the confrontation clause and whether or not a defendant was entitled to in-person cross-examination. I've actually I was a film major in college. I know that what the camera focuses on is not the reality, and so that doesn't, camera is not the same as in person. And United States Supreme Court has been pretty fairly consistent that it's the contemporaneous review of what's happening that makes the difference.
So your position would be that if a person goes to I'm talking about a member of the public, they go to the courtroom, they are told they cannot enter the courtroom, and there's a sign that says you cannot enter due to COVID restrictions, and they can watch it on live stream, your position would be that the courtroom would be closed?
Yes. I think if a trial court said we're going to conduct this trial by Zoom, all the litigants are in the courtroom, the public has to watch over YouTube, and defendant objects, then the trial can't proceed, because that's not a public trial. That's a internet YouTube live stream trial.
Counsel, thank you so much.
Thank you. And so we'd ask the court to clarify plain error for structural errors, or at least public trial errors, and grant Mr. Davis a new trial. Thank you.
Thank you, Mr. Helton. Ms. Clark, the case will be submitted. Thank you both.
Thank you.